Welcome to Chapter 9. This is an introduction to contracts. Probably one of the most important chapters, and it's actually not a chapter, but a group of chapters that we're going to be going over, which relates to contracts. Everything that you do in one way or another will involve contracts. So it's really, really important to understand the concepts. Unless you've been exposed to this area of the law, it's not as simple as it would appear. So let's talk a little bit about what we're going to cover in the chapter. We'll talk about, So we're going to talk about the development of the law of contracts. Then we'll talk about the basic requirements of a contract. We'll move on to the classification of contracts. Then we'll discuss a very important concept in contracts called promissory estoppel. I'll talk a little bit more about that when we get there. And then we'll also talk about quasi-contracts. Quasi-contracts are not written contracts per se, but they're created, or the law implies the existence of a contract due to the course of dealing between the parties and other issues. So again, we'll talk a little bit more about that as we get there. So let's start off by talking about the law of contracts. It's impossible really to overestimate the importance of contracts in the field of business. Obviously, without contract law and without contracts in general, it'd be impossible to do business. Almost every business transaction in one way or another involves contracts, and in particular contract law. So every business, whether we're talking about large or small, it doesn't really matter, must enter into contracts with either its employees, its suppliers, maybe its customers, or all of them in order to conduct business operations. So there is no way that you could really run a business nowadays and not be involved in a contractual transaction of some type. So let's talk a little bit about how the law of contracts evolved. And we have to go back to the common law, and most contracts are governed primarily by state common law. So very few statutes really govern contracts or transactions between parties. There are a few minor exceptions. If you recall, in one of the earlier chapters, we talked about uniform commercial laws, one of those being the Uniform Commercial Code. And so that has codified the common law in at least some areas of contracts. So, for example, the areas of sales under UCC II is covered by, has been codified. So we would look to statute for that. But for the most part, contract law is a creature of state law, state common law. And so that's the other reason why a lot of times there are some differences, not major ones, but there are some variations between contract laws from state to state. So they do vary somewhat. Although, as I mentioned, for the most part, they are the same. And if you really think about it, they have to be the same. There's no way you could ever engage or interact in any type of business if contract law wasn't uniform. So it really has to be in order for transactions to take place. Remember, businesses like certainty. So if I don't think or know that my contract is going to be enforced, why would I ever enter into a contract? It would be meaningless. So really what gives power or force to the contract is the law, and the fact that we know that contract is definitely going to be enforced. So that really is how contract law then has really evolved, and that includes employment contracts, services, service contracts. It also includes insurance contracts, real estate or real property, and anything that's attached to it. So fixtures and so forth, patents and copyrights, all of those areas really are affected by contract law in one way or another. So let's talk a little bit about the law governing the contracts. And again, we're getting a little bit here into part of the UCC, which I mentioned, which is the Uniform Commercial Code. So the way this chart is set up, and then it's in your book as well. The first question that you ask is the specific provision of the UCC applicable? So in other words, if we're talking, sale of goods, then usually the UCC applies. So I started at the top. I should be starting at the box that's to the far left. So the first question that you ask yourself is the contract for the sale of goods? If the answer is no, then general contract law governs or applies. So in other words, you'd be looking to state common law. If the answer is yes, then you move on to that box at the top there. And so the next question you would ask is there a specific provision of the UCC that's applicable? And it may or may not be. You need to make that it's a case-by-case analysis. If the answer is no, then again, that transaction is going to be governed by general contract law, so you're going to look to state common law for guidance. If the answer is yes, then the UCC governs, and you're going to be looking to the UCC, or again, the Uniform Commercial Code, for guidance as to what happens in that particular type of situation. Florida has codified the UCC. I believe it's Chapter 619 of the Florida statutes is where you can find the UCC, or parts of the UCC anyway. So every state, with the exception of Louisiana, has adopted either the UCC either in its entirety or in its majority. So that's, again, we're still talking about the development of the law of contracts. So the Uniform Commercial Code, as I mentioned earlier, Article 2 of the UCC governs the sale of goods. And by sale, we mean the transfer of title from the seller to the buyer. And that's actually a defined term in the UCC. The UCC also defines, and again, by UCC, we're talking about Article 2. It also talks or defines goods. And so they're defined as tangible personal property. And personal property is all property other than an interest in land or real property. Contract is also defined, and it's defined as a binding agreement that the courts will enforce. So if you have a contract, then you have a binding enforceable agreement. So here's another chart that actually talks about the contractual and non-contractual promises. Some promises may be contractual, some are not. So again, that's what this intends to show here. Some promises are enforceable even though they're not contractual. But again, this is just an overview. So let's get into the meat of things. This is really the analysis that becomes extremely important, and that is, what are the requirements of a contract? So in other words, how do we know? How do we know whether we have a contract or not? Because you may believe that you have a contract, you may have an agreement, but an agreement is not necessarily a contract, because you need all of these elements that we're going to discuss here shortly in order to have a valid and enforceable contract. the first thing that you need seems a little bit obvious, but a lot of times it isn't. And that's what we call mutual assent. So the parties to a contract must manifest either by words or by conduct that they have agreed to enter into a contract. So in other words, there has to be this mutual assent. So we both, or both parties, need to want to enter into an agreement or a contract. And so that's what we mean by mutual assent. One party is not enough. You need both parties to agree and to want to do this. The next thing you need, so you start off with mutual assent. Mutual assent is pretty easy. I mean, you either have it or you don't for the most part. The next step or the next element is called consideration. Each party to a contract must intentionally exchange a legal benefit or incur a legal detriment as an inducement to the other party to make a return exchange. So that's just a legal way or a fancy way of saying there has to be something of value that's exchanged between the parties. So for example, let's say I want to sell you my house. So the consideration will be, let's say you're the buyer. If you're the buyer, that's a pretty easy one because the consideration is simply the purchase price. If you're the seller, the consideration then is the house. So I have something of value, the house, which I'm going to be exchanging for something else also of value, the money or the purchase price. So that's what we mean by consideration. Or it can also be, as the slide here says, you could also incur a legal detriment. In other words, if you have a right to do something, a legal right to do something, and I make a deal with you that I say, if you don't do that, I'm going to pay you X amount, then that's also consideration. So for example, let's say that you're a smoker and I don't want you, I want to make you stop smoking. So I say, look, if you don't smoke for a whole year, I'll give you $10,000. Well, that's consideration on both sides, right? And the consideration has to be mutual. Again, me, the promisor, right? The person making the promise, that's pretty easy, right? Because I'm promising you $10,000. So that's pretty easy to say, hey, there's the consideration. It's the money. What about the person, the smoker? Well, the smoker, them giving up the right to smoke for a year, they're suffering a legal detriment. So in other words, something that they are legally entitled to do, they agree to refrain from doing that in exchange for the money that you're willing to pay. So that would also be valid consideration. So remember, right, when we're talking about consideration, money is the easiest way to remember, but money or goods that are exchanged that have value, but that's not always the case. Here's another very important subject, and it has to be legal, right? The purpose of the contract has to be legal, so it can't be criminal, it can't be tortious, or otherwise against public policy. So in other words, if I enter into a contract to purchase 1,000 pounds of cocaine, then that's not a valid contract because it's an illegal contract. It's for criminal conduct. So the courts will not enforce that. Just as a matter of public policy, we're not going to enforce criminal contracts. So again, that's just an example of that. Capacity, that's the other important element. The parties to the contract must have contractual capacity. And what do we mean by that? Well, the parties to the contract can't be minors. Minors cannot legally enter into contracts. So if a person is a minor, they don't have the capacity to enter into a contract. Also, if the person is intoxicated, they don't have the legal capacity. If a person is suffering from Alzheimer's, they don't have the legal capacity. So that's what we mean by that the person has to be over 18 years old and also has to have the right frame of mind, right? Which makes sense if you really think about it. If somebody's entering into a contract and we're going to hold them to that deal that they make, obviously we want them to be able to fully understand what it is that they're getting into, what their responsibilities are, and what their potential liability is if they don't comply with that promise. So that's why it's important that people have the capacity. So here's another slide, and again in your book, that talks about how you can determine whether an agreement is valid or not. We do make a distinction. Let me look at the future slides here to see if it goes into it. I don't think it does. Oh yeah, it does. Okay, I'm not going to spend some time on this. What I was really looking at here is I wanted to see whether I had slides that actually explain the difference between void, voidable, valid, and unenforceable, and I do. So I'm not going to talk about it right here. I'll talk about it in the other slides. But this is in essence kind of an analysis of how you determine whether you have a valid contract or not, right? So you start out with that mutual assent at the top, and you keep asking all of the questions till you either end up with a valid contract or one of the others there, the void, voidable, or unenforceable. All right, so let's talk about classifications of contract. As I'm sure you've seen already in the law, we like to make a lot of different classifications. So one of the first classifications of contract is either an express or an implied contract. Express, probably the easiest to understand and probably the one that most of you are familiar with. And that's an agreement that is stated in words, either orally or in writing. Most contracts are in writing. Then we have implied in fact contracts, and that's a contract in which the agreement of the parties is inferred from their conduct. So for example, let's say you're a painter and you come and you offer your services to me at my house. You'll say, I'll paint your house for $1,000. And I say, okay, do it. And so you start painting the house. Well, we don't have anything in writing. We do have words that have been exchanged. So I guess, we could say we have an oral contract. But, let's say we didn't discuss the terms of price. So let's say you offered to paint my house, but you don't tell me how much you're going to charge me. And I just say, okay, go ahead and do it. Well, price is an essential term of a contract. So most of the time, if you don't have a price term, you don't have a contract. But even though you don't have an express contract, you have an implied in fact, because if I agreed to having you paint my house, well, it's implied or inferred that I'm going to pay you for it. It's not, you're not working for free. We may have a dispute as to the price, as to how much you need to pay for it, but not as to whether we have a contract or not. We also have another distinction, which we call unilateral and bilateral contracts. So bilateral contracts, most contracts are bilateral, and that's a contract in which both parties exchange promises. So in other words, let me go back to my house example, my real estate. I'll sell you my house for $1 million. And so that's a bilateral, right? So the promises are, I promise to give you my house and you promise to give me $1 million. So that's bilateral. We both have to provide something of value to the other party. In a unilateral contract, it's a contract in which only one party makes a promise. So, in other words, an example of a unilateral contract would be the smoking example that I gave you before. So, if I say, I'll pay you $1 million if you stop smoking, then really, let me backtrack on that one, because I do think that would also be a bilateral, because you're also making a promise, right? You're making the promise not to smoke, so that wouldn't be a good example of one. Let me come back to an example on that one. I can't think of one off the top of my head right now, so I'll come back to an example of a unilateral contract. Here's the slide I wanted to get to before, the difference between valid, void, voidable, and unenforceable. It's important to understand the difference between each of those, because although they're very similar, and they actually, some of those anyway, have very similar effects, they are different. The first and most common is that you have a valid contract, and that's simply a contract that meets all of the requirements of a binding contract, right? So you have mutual assent, you have consideration, and so forth. That's valid. The next extreme, right, on the other side, is where you have a void contract. And what that means is you don't have a contract at all. So again, in my example where you enter into a contract to buy drugs, that would be a void contract. You never had a contract to begin with. A voidable contract is a contract that's capable of being made void. So an example of a voidable contract would be a contract with a minor. Remember, I said you can't enter into contracts with a minor, but let's say that you do. Let's say that a minor has a car, you want to buy his car, and so you enter into a contract to purchase his car. That type of contract is voidable. And what that means is that the minor has the election either to void the contract or go through with it, at which point it becomes a valid contract. So in other words, the minor has the election. If the minor wants to sell you the car, then the minor simply can, and at that point you're done, right? The deal is done. But if, let's say, the minor changes his mind and says, nope, I'm not going to sell you my car, and you later try and sue the minor to enforce that contract or for breach of the contract, the minor can simply say, that contract was voidable. I elected to void it, and I did. So we never had a contract at all. And that's exactly what a court would say or find. Unenforceable contract is a contract for the breach of which the law provides no remedy. So again, those are contracts that are unenforceable. So contracts that are against public policy, for example, would be unenforceable. So if I enter into a contract for, let's say that I enter into a contract with you where I say, I'll pay you $1 million if you don't marry a white person, right? So that would be a racist contract, and it would actually violate public policy. And so that contract would be unenforceable. I could not enforce that particular contract. There's another different or classification of contract, and that's executed versus executory. An executed contract is a contract that has been fully performed by all of the parties. So in other words, going back to my example of the real estate, right? I sold you the house, you paid me the money, we're done. So that's what we called an executed contract. There's nothing left to be done. An executory contract is a contract that has yet to be fully performed. So we may have entered into, let's go back to my real estate example. Let's say that we entered into a contract, we signed the contract, but we don't close for 30 days. So you have a valid contract, but that contract is an executory contract. It's yet to be fulfilled, right? I have to still give you the house, and you still have to give me the money. So that's the difference between executed and executory. We also have formal and informal contracts. A formal contract is an agreement that is legally binding because of its particular form or mode of expression. So formal contracts would be usually contracts that need to be notarized. So for example, a deed would be a formal type of contract. Remember, a deed is the document that transfers title from one person to another. Most real estate contracts, for the most part, are formal. So those are the ones that, again, need to be notarized or have witnesses or so. Usually require what I'm going to call additional things to be done. An informal contract is all contracts other than formal contracts. I would say most contracts are informal contracts. Don't get confused. Just because they're informal does not mean they're not enforceable or that they're not real contracts. They're still valid contracts. It's just that, again, you don't have all the requirements that you do for some of the other contracts. Another type of a formal contract would be like a will, for example. Those are more formal, have more requirements, in other words. So let's talk a little bit about promissory estoppel. Promissory estoppel is a doctrine enforcing some non-contractual promises. So even though if there are some promises that don't create a contract, they may still be enforceable. Here are the requirements, though. It's a promise that's made under circumstances that should lead the promisor, that's the person making the promise, reasonably to expect that the promise would induce the would induce the promise to take, and it shouldn't say promise, would induce the promisee, there's an E missing there at the end, so the person receiving the promise to take definite and substantial action, and the promise does not take such act, and the promisee, again, it should say promisee, not promise, with another E at the end, and the promisee, the person receiving the promise, does not take such action. Hold on, there's lots of spelling mistakes here, which kind of actually changes the wording here. The definite and substantial action. Let me reread this for a second. At the very bottom actually should be, and the promisor, which is the person making the promise, does not take such action. So let me give you an example of promissory estoppel. Let's say that you're interviewing for a job, and so you fly, and let's say you live in New York, and so you fly to Naples, you interview, and I really like you, and so I say, you know what, I'm gonna give you the job, and you're really happy, and you say great, and so you go back to New York. So then I give you a call and say, hey, I really need you to start here in 2 weeks, so can you do that? And you say yes. And I say, okay, well, your salary is going to be X. Please make sure you get here as quickly as you can, make whatever arrangements you need to make. So in reliance on my promise, and that promise being that I'm going to give you a job for X amount of money, you sell your house in New York and you move your family to Naples. Let's say when you get here, I say, oh, by the way, you know what? Sorry, that job's no longer available. I hired somebody else. Well, I can actually sue you to enforce that promise. And I'm going to sue you under the theory of promissory estoppel. they're very rare, very limited circumstances where it can be used. It has to be that egregious, like the example that I gave. You really have to do something, what we call legally, it's called detrimental reliance. You have to do something that really, that based on the person's promise, you have to take some action that if the person doesn't deliver on their promise, it would actually hurt you. So that's what we mean by promissory estoppel. So not common. And it makes sense if you really think about it, right? Because if we're going to induce somebody to do something and they actually do it based on the promise that we make them, and they're hurt by it, right? They either spend money or sell something or whatever the case may be, then obviously they should be compensated for that promise, even though it may not rise to the level of a contract. So the remedy, a court will enforce the promise to the extent necessary to avoid injustice. So in other words, in the case, my example is pretty extreme, right? Because you sold the house. Obviously the court can't force the person to buy a house, but they can certainly give you the damages for the difference. Let's say now you have to buy another house, and it's actually, you sold your house for $500,000, and the cheapest house you could find in that similar area is now $700,000. Well, your damages would be that difference, the $200,000. So that's usually how a court would look at it. So let's move on to quasi-contract. The quasi-contract is an obligation not based on a contract that is imposed to avoid injustice. So this is the type of situation where we don't really have a contract, but we act like we do. And so the court is going to imply a contract. In other words, a quasi-contract is an implied in law contract. So let's look at some of the requirements. A court will impose a quasi-contract when the plaintiff confers a benefit upon the defendant knows or appreciates the benefit, and the defendant's retention of the benefit is inequitable. We call that unjust enrichment legally. So in other words, let's go back to my painter example, right? Let's say you come over to my house, you start painting my house, I watch you paint my house, and when you're done, you say, hey, it's $5,000. And I say, wait a second, we don't have a contract. I never agreed to you painting my house. I said, but you watch me paint your house. And so at that point, you're likely going to have to pay for it. Now, there could be a dispute as to the price, right? Maybe what the court will say is, we'll try and determine what the reasonable price is for the work that was done, but you're going to have to pay for it, right? You received the benefit, and you can't just keep it without paying. That's what we mean by a quasi-contract. And again, right, the remedy there recovers the reasonable value of the benefit that she conferred upon the defendant. And again, so that's really what the court's going to try and determine, is what was the reasonable value of that work that was done. So here we have a slide that kind of puts it all into a context, the type of promise, the requirements, the remedies, and then we have the contract, the quasi-contract, and the promissory estoppel. So this is actually a very, very short chapter, and this is really it for this chapter. But I want to make sure that everybody's familiar and understands. So please make sure that even if it's a short chapter, you pay attention to it. You understand the different elements of what's required in order to have a contract, right? Mutual assent, consideration, capacity, right? Those are the types of things you need to understand. And also understand the different classifications. They're not always easy to remember or easy to understand. right? Understand the difference of when you have a void, voidable, valid, or unenforceable contract as well. And remember, promissory estoppel based on the notion of unjust enrichment. Same thing with quasi-contracts, also founded on the notion of unjust enrichment, which means if you received a benefit, we will not allow you to retain that benefit without paying for it just because there wasn't a quote-unquote valid contract. So if you have any questions about this, please feel free to email me, and we'll talk a little bit more about contracts when we meet in class in person.